Hello and welcome to Health Affairs This Week. I'm your host, Jeff Byers. Today we are going to talk about the Supreme Court decision to reject a lawsuit challenging the FDA's regulations regarding mifepristone, an abortion pill. As a result, the drug will currently stay on the market. Relatedly, Health Affairs is hosting an insider exclusive Lunch and Learn event on July 10th to discuss health and healthcare policy decisions expected in the closing days of the Supreme Court's 2023 to 2024 session. If you sign up for Insider before July 1st, you can still take advantage of our promotion celebrating its second anniversary. Click the link in the show notes and use code INSIDER at 2 to join us on July 10th. On the pod with me today is Andrew Twinamatsiko. Andrew is the Director of the Health Policy and the Law Initiative at the O'Neill Institute for National and Global Health Law at Georgetown Law. Welcome to the program.
Oh, thank you for having me, Jeff.
We're here to talk about the Supreme Court and mifepristone case. So, Andrew, thanks for joining us. I thought it'd be a great way if you could just give us, for people like myself that might not be up to date with all the comings and goings of the Supreme Court, can you just give us a quick primer on the Supreme Court? How many cases do they take a session? They're obviously very important, but can you draw that out for us?
Yeah, no, and that's really a good way to start, because the Supreme Court doesn't really listen to hear every case where it's asked to intervene. The court limits its docket, and usually I think it's approximated that the court, that between 5,000 and 7,000 new cases are filed in the Supreme Court, but the court actually gives plenary review of up to maybe 80 cases, and then others are disposed of. So between 100 and 150 cases in total. That's what the Supreme Court disposes of each term. And the court has a term in which it sits. And by federal law, the term of the court always starts on the first Monday of October. And it's supposed to go until the last Sunday before that. But then your court usually goes into recess for the summer, in late June, early July, and we'll see how this happens soon here after the court in just this week.
Thanks for sharing that. That's great to know. I guess one thing or one follow-up question is what kinds of cases usually level up to the Supreme Court level? Why do generally the Supreme Court hear certain cases and reject others?
Yeah, no, and that's actually also a great way to get an insight in the kinds of cases that the court hears. Like I said, the court has its docket is discretionary and doesn't have to take every case. And so usually the court takes important cases. And these happen when the case, for example, there is what the so-called a circuit split. There's different federal appellate courts, and sometimes they don't get to the same conclusion on the same issue. And so when there is a difference of opinion in the federal courts at the appellate level, then sometimes the court will intervene to address that. Or if the case is is egregiously wrong, the court will take that up to remedy the wrong. Or if they think that the case really will present an issue that will have precedential value, then the court will take that. And then sometimes the court will take cases from state courts that present constitutional issues. And so those are the kinds of cases that the court hears and limits its docket to kind of not stretch that out very much.
Okay, so quite a different number of reasons, but no one touchstone reason. So that is great when we want to think about the recent decision for the mifepristone case. So can you tell us a little bit about what was the legal argument for that case coming into the courts, and ultimately why did the court reject it?
Yeah, so the question before the court was really whether the FDA had acted wrongly when it approved abortion medication, like you mentioned, mifepristone, back in the year 2000, and several steps that the FDA had taken to ensure that the abortion medication is available for folks to safely use and to use safely and effectively. But I want to take a step back and situate this conversation in the whole process through which actually got us here. So we have to go back to the year 2000, which was the first time that the FDA approved mifepristone, that was marketed under the name Mifeprex, which is made by Danco Laboratories. So that is in 2000. And when the court approved that mifepristone for the first time, it imposed restrictions to ensure that there was a safety in use. And those restrictions included you had to go through to the doctor 3 times, and it could only be used to terminate pregnancies up to 7 weeks. But then we have changes made within 2016. So there's what the federal law calls the risk evaluation and management strategy (RAMS), which accompanies certain drugs to ensure that they're safely used. And so what the FDA did in 2016 was to revise the so-called RAMS and extend the time through which that abortion medication could terminate the pregnancy up to 10 weeks, and then limited the in-person visitations to one visit, and then also would allow even mid-level practitioners like physicians assistants to prescribe it. So that's 2016. Then in 2019, the FDA actually approved the generic version of mifepristone. And then again in 2021, the FDA determined that they could actually ease the burden of access for the patients. And then while it was also ensuring that the access wasn't really very risky. So it allowed mifepristone to be dispensed via telehealth. So that's the whole background behind it. And then we have 2 years ago, the court come in and say that the Constitution no longer protected the right to an abortion, in Dobbs v. Jackson. And so that really precipitated a lot of action for folks who are opposed to abortion to challenge ways through which abortion could be procured. And therefore, we have folks running to Texas, a district court, federal court in Texas, saying that the FDA acted wrongly when it approved mifepristone to begin with, and different steps that it took to ensure that birthing persons could access without being burdened with all these steps that didn't mitigate any risk to it. So that's really the background.
So, real quick question: is there any significance that it was in Texas? Like, was there, because you said ran to Texas? Could it have been in any state, or was there a significance with Texas?
Yeah. So, I mean, I think and this is something that folks, anybody who is attuned to the legal goings on understands, that there has really been a huge shift in the composition of the courts in the last few years. And the Washington Post and the New York Times have ran stories about the courts in Texas having an ideological bend. And somebody had referred to Texas as the jurisdiction where health laws go to die. So folks strategically file some cases in some district courts in Texas, that they'll find a judge knowing that they will most likely find a judge that will agree with their position. And so that's why it was strategically filed in Texas, to hopefully find somebody who will agree. And they did.
Great. Well, thanks for sharing all of the context. Ultimately, why did the courts reject it?
As I mentioned, the folks went to Texas, and of course the district court agreed with them, and the court went through appeals. But once the case got before the Supreme Court, there was a determination that the folks who so challenged this case, were out of time to challenge what the FDA did in 2010. The only issue that was to be determined was whether the FDA had appropriately acted when it revised the rules as to access, the regulations as to access, in 2016 and in 2020. And so, again, I want to take a step back and situate the federal courts in this conversation. So, under Article 3 of the Constitution, it limits federal judicial jurisdiction to cases and controversies. Federal courts can give advisory opinions. You have to have a dispute between at least two individuals to invoke the court's jurisdiction. Otherwise, the court would be like a roving commission, finding out what issue is at stake and addressing it. So, in order to come before the court, you have to show that you have a stake in the dispute. So basically the question, and now I'm going to quote Nini Leaks here, where she says, "Now why am I in it?" before you
Right.
before you come to the court asks, "Why are you in it?" And so why these doctors who challenged the abortion medication, what they claimed they were in it for was because they claimed that easing access to abortion medication increases the risks for women to seek emergency care. And once they seek emergency care and go to the doctors will be forced to provide that emergency care and be complicit in providing abortion. That was one of the claims. The other claim was that they would spend a significant amount of money trying to understand a medication abortion and trying to educate their members. These are associations of doctors. So they also claim that they will be financially harmed because if more pregnant women sought medical care from the doctors, it would divert the doctors from taking care of the other existing patients, which would expose those doctors to malpractice liability, and then consequently hike up their insurance, their malpractice insurance costs. So those are some of the arguments that they raised about this set of events that the approval and the access to abortion medication would roll in and consequently create problems for them.
And the court wasn't buying it?
Yes, the court said, well, all those things that you have said, you are not really likely to show that that actually happens. The court said, that the line that you're trying to draw of causality is really attenuated to present harm that you claim that you're having. And the interesting thing is that the court could have stopped there, though. The court could have stopped that there and said, this is a stretch, so you can't really claim to be harmed. Like, there's no reason why you are in it. But the court also said that even if, let's say, you are called to provide emergency care to women facing complications from abortion medication, there are federal conscious protections that would insulate you from providing abortions that you're opposed to. And so for that reason, the court said there's no way you're going to show that you're harmed.
And so one might think that that puts a period on that sentence, but I assume that there also could be a possibility that a case like this could try to make its way back into the courts. Is that right?
Yeah, definitely. I mean, I think
Okay.
it's not over. So the court resolving the issue on standing grounds. This is the so-called show me how you're harmed. Why am I in it standard? Really doesn't resolve the issue that's underlying of whether the FDA acted appropriately when it relaxed the requirements or in-person dispensing, and also allowing it to be accessed via telehealth or other mid-level practitioners provided. And so what actually has already happened is that, and I want to take a step back and and highlight something that some of the justices emphasized during oral arguments. They kept saying, this justice Alito kept saying that somebody should be able to sue. And the court kind of steps away from that in this decision and says, well, we're not saying that nobody can sue. We're just saying none of these people who are here can sue. And but right now there are, so in the lower court, 3 states, Idaho, Kansas, and Missouri, have actually intervened. So the court sent this case back to the lower court to dispose of it according to how the court had decided. But now 3 states, as I mentioned, Idaho, Kansas, and Missouri, have already intervened to say, hey, if the doctors don't have standing, if the doctors can't come in, there are ways through which we can show that we are harmed by this law that we disagree with. And so the case is likely to be, the case is still alive in the lower courts. So it's likely that we'll have round 2 of the Mifpristone legal challenge before the Supreme Court.
Okay. And then as we kind of wrap up this conversation, then I'm sure it's a big thought on individuals' minds that it's election year, and this is a very hot button issue. You see, in terms of the Supreme Court or with the legal standings and cases, how this case or those lower court cases might influence the election?
Yeah, definitely. I think, and I'm not really too caught up on all the old political rhetoric around that, but even during the oral argument in this case, there is questioning that came following this law called the Comstock Act, a law that was enacted in the late 1800s that prohibits, it's an anti-obscenity law, but it's so broad and capacious that it also prohibits mailing of abortion materials, whatever that means. And so you see some judges pressing on that, and it seems it gives folks politically maybe some ammo to weaponize that law and say, hey, by the way, federally, you can't even mail this medication. So even though the FDA approves it and says, hey, it's safe to use even via telehealth, you can see some folks, even some states, weaponizing that and saying you can't mail that based on this obscure law from the 1800s or some other leveraging of that law to also further hamper access to abortion medication.
Well, Andrew, thanks for joining us today on Health Affairs This Week. Is there anything that you want to point listeners to that you have going on?
One thing that I could point folks to is some of the materials that we've written on this same subject. We have an article right now on Health Affairs Forefront touching on this very subject, and then other things on the O'Neill website that address this issue extensively.
Okay, well, great. Listener, check the show notes, and we'll be sure to point them in that direction. And with that, Andrew, thanks again for joining us on Health Affairs This Week, and thanks to you, the listener, for joining us. Please share it with the legal expert in your life, and have a great weekend.